Yeah, so I think the first thing we're going to talk about, there's a video made by Matt Christiansen about Ketanji Brown Jackson. Oh no, I'm going to say that name. I'm probably going to mispronounce the name a lot in this video, but that's okay. That's something that you guys deal with because you're watching a white dude in college stream. It's like, okay, a white dude from South Dakota streaming. It's like, no. But yeah. You get what you pay for, you know? You guys pay for nothing, so I'm not going to pronounce anything right. But yeah, let's jump into that video. I think I should be able to skip the ads. Yeah, I wanted to watch this video. I did watch it beforehand, but I wasn't really paying a ton of attention. I more just watched it, try to figure out what was happening in it because someone said it in the chat the other day. We were talking about that. And I kind of wanted to talk about that. So I watched it, had some things to say, and now it's time to actually put them into words. I had some thoughts, let's say. Let's see if I can. Oh jeez, is this gonna work? Oh no, my OBS is frozen over here. Okay. We love the Wi-Fi here. We love the $30 a month Wi-Fi. I guess you get what you pay for. Okay, here we go. Okay, there it is. Awesome. And transition. Let's go. Let's do the theater mode. Oh.
As the Ketanji Brown Jackson Supreme Court hearings wrap, and despite the controversies, it is expected her nomination will be confirmed in early April, all but a guarantee now with Senator Manchin's announcement of support. It's amazing to consider just
Yeah, because it seems like she's very bipartisan. Like everybody seems to support her. So the Republicans are throwing some things at her, like the whole Joshua Hawley thing about the child porn. Or the thing where she's like under prosecuting those cases, which we're gonna get into this video. So.
How bad some of the judges' answers were, and I get it. When you take a grilling for several hours straight, it's tiring, it's frustrating. You're bound to make some mistakes, but the thing is, Ketanji's worst answers weren't actually on surprise attacks at all. They came with explicit advance warning. Outside of the what is a woman insanity, the most controversial piece of the judge's history and testimony is her record on child pornography sentences, more lenient than prosecutors' asks and federal sentencing guidelines in every case that she's handled. And
yeah, but I think it's the case that for most of these most child porn cases, the consumer of child porn gets underneath the suggested sentencing anyway, so it's not, I don't think it's out of the ordinary. I could probably look it up. I could probably look up the percent. That would take a while though. I've seen these percentages before. Take my word for it. Do some research on your own if you disagree with me. If you find anything different, post it in the chat, please. I don't want to take up too much time doing a bunch of all the Google stuff.
For whatever you think of the fairness or accuracy of that criticism, there's no way to claim it was an ambush. Senator Hawley, leading that line of attack, publicly published his case last week and told the judge personally on Monday, these are the specific cases I am going to ask you about. I'm not looking to smear you. I'm looking for your fair, prepared explanation.
Some have asked, why
that's reasonable, though. Telling her beforehand, I feel like that's fairly reasonable. He's doing it in the right way. It just, I don't know. It seems like bringing child porn prosecution into it, bringing child porn, it's like, I feel like that is the perfect issue just to set people off and just polarize everybody, because people struggle to think rationally when you get pedophilia or anything involved. They the initial thought from a lot of people is like, oh yeah, let's fucking chop their balls off and throw them in a cage and hang them or some shit. Like it's a little disproportionate to what the crime is. Obviously, it's a bad thing. I'm not like a child porn advocate or something. I think especially the people who produce it, they're child exploiters, and people who molest children, then they deserve to go to prison for a long time. But we can get more into that.
I raised these questions ahead of the hearing. Why not wait until the hearing? I'm not interested in trapping Judge Jackson. I'm not interested in trying to play gotcha. I'm interested in her answers, because I found in our time together that she was enormously thoughtful, and I suspect has a coherent.
Yeah, it's so weird because this feels like such a gotcha thing. Because I don't. Yeah, but we can.
Parent view, an explanation, and a set of way of thinking about this that I look forward to hearing.
And yet, Jackson's apparent prepared answers included, I don't know the specifics of that case.
I don't remember in detail this particular case, but I do recall it being unusual.
Even though that specific case was cited ahead of time to give her the benefit of preparation. But even I don't know my own record is...
See, that's... I guess I can understand it, like, not... I don't know, but if it is something that he gave advance notice of, I don't know how much advance notice necessarily it was, but it probably should be something she should have looked more into. But I can understand saying, like, hey, I don't remember the exact specifics, this was a long time ago. Even if you go back and, like, research the case, you're not going to remember it as well as you did when you were actually judging the case. Yeah, I think you don't, it's hard to go back and remember exactly why you made a certain decision, even when you are represented with all the evidence of that case. Like, I could probably, let me think of an example. I could probably remember certain details of a cross country meet that I had in high school. I couldn't remember like very specific details of those, even if I did go back and like did all the research about it. Like I have a different thought process now. I have a different way of thinking. So you can't entirely blame her, but she probably, I don't know how much of this is like clipped out of context. I don't know what the context surrounding this is, but that's probably not the best answer. She probably could have said more than just, oh, this was an unusual case and I don't remember the specifics. I feel like she could have probably gone more into stuff that is of public record if she would have prepared more for her answers, but it's understandable.
Still a better answer than, yeah, well, this is the sort of crime that happens to the best of us unwittingly. In between browsing Facebook and shopping on Amazon, who hasn't accidentally distributed a few thousand child porn images?
You can receive, you can distribute tens of thousands. You can be doing this for 15 minutes.
Okay, the distribute thing is a little strange. It's possible that you could receive child porn just on the internet, like just, I don't know, I feel like Facebook would take that down. But it's possible that like something could just like pop up, but I don't know if that's what the kid, I don't know. I don't know the context of this specific clip either. I wish he would provide a little bit more context to these clips, because I don't know exactly what she's being asked in these responses. I think that's an issue in general with this video, but I mean, I don't know exactly what she's responding to, so I can't. Yeah, let's hear the rest of this.
And all of a sudden, you are looking at 30, 40, 50 years in prison.
Good.
Who knows? You might spend only...
Oh, that's absurd. Yeah, 30, 40, yeah, that's insane. Like, for example, let's say I were to like go on Twitter or something and some random message request sends me like some bit of child porn. Like, it's like, okay, is that, do I deserve to go to prison for that? Like, I didn't ask for it. I didn't consent to that being sent to me. I think the person who sent it should probably go to prison. But I don't think necessarily if I'm receiving that, it should be a problem. Or another thing, let's say a parent has a kid and like, I don't know, does something stupid and like posts like a bathtub picture or something, or like something where their child is not fully, or I don't know. I can't think of a specific example. Like, should that parent be prosecuted for posting like a baby picture of a kid where the baby might not be fully clothed? But I don't know.
15 minutes committing one school shooting, and then all of a sudden you're looking at life in prison. Yes, a whole lot of crime can fit into just a few minutes, and that's a truth that's certainly not unique to this one. Even serial killers spend 99.9+% of their lives not murdering, but it's the brief murdery parts that...
Yeah, see, I think this is true. I think most child porn cases are not like these weird nuanced examples, but I think there is some room for nuance that requires some sort of judicial discretion there discretion from the judge. So you can think of like a wide range of different possibilities for what exactly these cases could be. So it's like, it seems really weird to have these like insane sentences that should probably be reserved for the person with like multiple gigabytes like in their in one of their folders on their computer. Like it seems absurd.
That the law is concerned with. And why should crime committed digitally deserve more lenient punishment anyway? If I rob you by hacking your Venmo, is that a lesser crime than physically plucking the cash from your wallet instead? And as though it's so common or understandable anyway, if you're watching this video, you likely have years or even decades of internet experience behind you, and yet that history includes not 15, but exactly 0 minutes of child pornography distribution or consumption. I guess you're one of the lucky few. Your days of nobility and virtue are apparently numbered. It is baffling that with warning and...
See, that's true for me, but I don't know if a lot of your viewers could relate to that. But I don't know.
preparation time, these are among the best answers that Jackson and her team could come up with, when there's a much more plausible one to go with. And in fairness to her, she did go with it. She just muddled it up by straying away from it to much worse and sillier arguments. It's not a rationale I agree with, but it's a lot less clownish than I don't know my own record, even with advance notice to look it up, and whoopsie, I accidentally uploaded thousands of child porn files to YouTube instead of this video. It goes like this. Current federal law insufficiently distinguishes between production and possession or sharing. And producing the material is worse than simply consuming it or sending it to somebody, because production means the direct abuse of a child. And to the extent that judges have full...
Yeah, because I definitely think that I agree with this. Because, yeah, obviously, as he said before, like, production of it, distribution of it, those are much different offenses than consumption of it. I think consumption of child porn points more to a sexual illness that somebody has, pedophilia. Or pedophilia can be conflated with child abuse in and of itself, and I think that's bad. But someone who is attracted to children but never actually does anything that abuses them, I think that is an illness. And the actual actions that you take after that, those can be criminal. Those can actually harm children. But the people who actually who just have an attraction to children, I think those people should be treated more in a therapeutic sense. Like go to therapy, take drugs that lower your libido if you can't actually resolve the problem. And yeah, I think now viewing child porn, that goes a step further, because then you're indirectly supporting the abuse of children. So I think that definitely deserves some criminal punishment. But I do think that the justice system definitely conflates consumption with production way too much, because this is the consumption is someone acting out an illness in a way that indirectly supports child abuse. But like the producer, they're actually like rounding up children and producing child porn with them. So I think it makes sense to differentiate between those things. And also, there's a very wide range of possible things that could be considered viewing child porn, like or possession of child porn. For example, like if an 18-year-old has a 17-year-old girlfriend, and that 17-year-old girlfriend sends him nude pictures, is that possession of child porn? Well, under the law, I think that would be considered child porn. In fact, I think it's considered possession of child porn if a 16-year-old sends their also 16-year-old boyfriend / girlfriend nude pictures of themselves. So it's a very, very, I don't know. There's times where it gets blurry, I think.
Discretion in sentencing these cases by virtue of a 2005 Supreme Court case that made congressional sentencing guidelines advisory and not mandatory. Federal judges have, as a trend, sentenced possession and distribution on the lower end of the sentencing range.
See, and I think that makes sense because, yeah, as he just talked about there was a recent case, or I don't know how recent it was actually. There was a case that basically made sentencing based on sentencing for child pornography, made it advisory rather than mandatory sentencing, which I think is reasonable because a lot of no two cases are the exact same. So we do need some consideration of context when deciding how much to prosecute someone for. I don't think there's some intrinsic amount of time that someone deserves to go to prison for because they violated this law in like a child porn law in a certain way. I think there are different ways to violate that law, and I think that needs to be considered in sentencing. And I think that is probably the biggest reason why why Ketanji Brown Jackson, as well as most justices, most federal judges, or judges in general, sentence people lower than the sentencing guidelines for child porn consumption.
Case that made congressional sentencing guidelines advisory and not mandatory, federal judges have, as a trend, sentenced possession and distribution on the lower end of the sentencing range. A 2021 report from the U.S. Sentencing Commission, of which Brown Jackson is the former vice chair, found that in 2019, 59% of non-production offenders received sentences below the guideline range as a result of this issue. Enhancements that were designed to apply only to the most serious cases now apply to most cases in general, because computer and internet storage and distribution of the material has put it on a scale much larger than when the law was written. And of course, that's not an argument without its flaws. It's just an argument that pushes Jackson more into the judicial mainstream rather than some outlier. But the question...
I think I generally agree with that argument. He's saying that it has its flaws, but he's not pointing to any of them, so I can't directly attack what he would say in response to this. But I do think that's a fairly reasonable argument. Yeah.
Remains, what if the mainstream is wrong? And not just wrong on the question of what are the appropriate sentences for these offenders, but wrong on the question that's more central to her confirmation, wrong on judicial philosophy. Because fundamental to this argument that Congress hasn't appropriately updated the law to meet the times is that judges should correct that issue. That if judges decide that the law isn't modern enough, or kind enough, or considerate enough, or is otherwise subjectively deficient, that judges should insert their own policy preferences to correct that matter. And that is an argument that takes a very clear side on what is more important, the application of the law as written or the judge's personal political opinions. It's not as though...
I think he's conflating something here. He's conflating what the law is with the judge's discretion on sentencing. There's a difference between saying that, oh, I'm going to follow the law to the letter, and saying that I'm going to adhere to the sentencing guidelines put forth by the U.S. Sentencing Commission. There's a huge difference there. I think that it's the difference between what the job of the jury is versus what the job of the judge is, essentially, when it comes to actually like sentencing people and determining whether they're legal or illegal. The judge obviously has other roles in the trial, but the jury's job is to say, okay, did this person violate the law or not? And the judge then, based on the context after the jury's verdict, decides on sentencing after that. And the sentencing is very much up to the judge's discretion. So saying that, oh, I don't believe in certain sentencing guidelines is not trying to play fast and loose with the law, saying that, oh, this law isn't modernized enough. No, it's saying these sentencing guidelines don't fit the crime in the context that I'm seeing it committed in. So I'm going to go under those guidelines as a judge based on my judge's discretion, which is a fundamental part of how our law works.
Prioritizing personal political opinions over the law has stopped the confirmation or careers of justices prior. In many ways, that too would be a continuation of the norm, regardless of what the law says. But the trouble isn't just that it's the wrong philosophy. It's that it's in opposition to the philosophy that Jackson herself claims to hold. It's not just a contradiction with constitutional fidelity. It's a contradiction with Jackson's own testimony. The hearing's first questions came customarily from Judiciary Committee Chair Dick Durbin, who was trying to get out ahead of all of this incoming criticism. One of those criticisms being potential judicial activism, judging cases based on what you want the law to be instead of what the law is. And so Dick Durbin asked Jackson about her judicial philosophy. And if you only read the transcript, you'd think it was Scalia or Thomas talking.
So would you like to comment at the outset?
I think my camera did something weird. Hold up, give me a second. Let me fix that quick. Sorry about this. Sorry, my camera is not necessarily the best. Activate again, and awesome. Sweet. Okay. Beautiful. Okay. So let me just go back and remember what he just said. Okay. Let me catch myself
instead of what the law is. And so Dick Durbin asked Jackson about her judicial philosophy.
So
and if you
the whole concept of judicial activism, I think I probably agree with Christopher Christiansen, is his name? Yeah, Matt, I probably agree with Christiansen that judges shouldn't be super active in deciding, oh, this is like, I'm going to reinterpret this law to fit my personal beliefs. I think the purpose of the judges, read the Constitution, read the law as it is, and interpret that as it actually is, as the founders intended it, which I think I probably agree with most conservative judges on that. And Ketanji Brown Jackson also agrees with that philosophy. That is the philosophy that she puts forward, which is why I think she has bipartisan support. Yeah, she's also a very qualified. She's also a very qualified judge, especially when you look at her comparison to other judges. So those two reasons, I think she has a very palatable judicial philosophy that isn't a big fan of like all the judicial activism that one might expect from if like Bernie were to be the president. Like he would probably put someone forward who would take a very active role in reinterpreting the law and modernizing it. I think Breyer has that philosophy, if I remember correctly. But yeah, Ketanji Brown Jackson, she has, as she explains, she has a judicial philosophy that's opposed to judicial activism, which is what he's going to use as his like big contradiction here, I think.
When you read the transcript, you'd think it was Scalia or Thomas talking.
So would you like to comment at the outset of those who are looking for a label, what your position is on judicial philosophy?
Adherence to text is a constraint on my authority. I'm trying to figure out what those words mean as they were intended by the people who wrote them. I'm looking at original documents. I am focusing on the original public meaning because I'm constrained to interpret the text. I am not importing my personal views or policy preferences. The entire exercise is about trying to understand what those who created this policy or this law intended.
And hey, that's great.
Yeah, I think that is super based. That's definitely the way that I think about the law as well. Like the job of judges, the job of the courts in general is not to reinterpret the law and to insert like new laws and like new reinterpretations of the law. It's as much as it sucks in certain cases where it's like in a lot of drug crimes, for example, I don't think drug laws should be a thing. And I wish that like it would be nice if I were in a jury to say, you know what, I don't believe this law is a thing, so I'm just going to say this person isn't guilty and not fine them. Or if I were a judge, it would feel great to say that. Like, okay, I'm just going to sentence you to no time, even though you're guilty of this. It's like, okay, well, no, that's not your job as a court. If the courts are just allowed to interpret the law willy-nilly, you run into all sorts of problems. We need objective adherence to the law. One big problem with a lot of dictatorships is that they applied the law or they would interpret the law based on just the whims of the justices, the whims of the state, which was a major problem because then you basically just have unlimited power as a government to determine who you want to throw in prison, what exactly you want to do, which is tyranny by definition almost. So I think it's important to keep those functions separate, keep the legislature separate from the judges. The legislator, they write the laws. The judges, they don't question what the legislator writes unless it violates the Constitution, of course. But the judges, they don't question that. But also the Constitution, oh gosh, we're going on a tangent. The Constitution, determining whether something violates the Constitution is the job of the Supreme Court, not necessarily the lower courts, I don't think. Correct me if I'm wrong on that, actually. Yeah, so the purpose of the judges, enforce the law, or not enforce the law, determine whether someone violated the law. The purpose of the legislator is to write it, and they shouldn't, like, the judges shouldn't rewrite the law, essentially, in the most long-winded way possible to explain it.
To the extent that you believe her, is that sincere philosophy? Is that just lip service? I'd say decide for yourself, but Jackson and her team have already decided for you. The exact opposite is their argument to justify her sentencing in the child porn cases. In that situation, the text and the intent of the statutory authors is not, in fact, constraining. It is not, in fact, the most important consideration. All of that is secondary to the judge's view of how modern times change the application of that law.
The original law was...
No, I think there's a difference between sentencing and interpreting the law as it's written. Like, if she started saying, like, oh, this isn't necessarily illegal because when this law was written, it didn't account for digital child porn. So digital child porn doesn't need to be illegal. Like, we don't need to prosecute those people. That would be a problem. That would be a reinterpretation based on her own beliefs. However, sentencing someone lower than sentencing guidelines, that is a contextual thing that requires the judge's discretion. So I think there is a huge difference here, and it's not a contradiction of her philosophy opposing judicial activism to say that in certain contexts I will sentence below the in most contexts I will sentence below the sentencing guidelines. There's a huge difference between those two things. Now, if those guidelines were mandatory, then I do think that it would be a problem if she sentenced below those, because then she wouldn't be following the law. However, when those guidelines are just recommendations, and it's still up to the judge to determine how long how much those sentences should be.
It was written at least 9 or 10, maybe longer, years ago, and the quantity of material was relevant to the sentencing. And now that we have computer access to voluminous amounts of material, it has raised questions, has it not, within the judiciary as to the appropriate sentencing in today's circumstances.
The guideline was based originally on a statutory scheme and on directives, specific directives by Congress at a time in which more serious child pornography offenders were identified based on the volume, based on the number of photographs that they received in the mail. And that made total sense before, when we didn't have the internet, when we didn't have distribution. But the way that the guideline is now structured is leading to extreme disparities in the system because it's so easy for people to get volumes of this kind of material now.
Okay, but even if we grant changes in technology,
yes, so this is a contextual difference. This is a difference in the context of the cases that she's seeing. So the difference here is, like, when you're changing your sentencing based on the context of the case, I think that is perfectly fine and not a reinterpretation of the law. Yeah, but that's what I've kind of been explaining already.
Technology and disparate outcomes as concerns, the question is, concerns for whom? Who writes the law that should consider these factors? Is that Congress's job? Or is that a judge's job? Jackson told us just 10 minutes prior to this exchange that is not a judge's job. Yet here she is accepting and expanding on Durbin's premise that Congress didn't get it done, so now it's up to her to do it from the bench.
And in fact, what we're doing...
No, so the issue is Congress has a law that applies, like, very specifically to certain cases that were in the past. If they wanted to create like new mandatory sentences for modern digital cases, then they would they would have to write a new law because of that. Because right now the law is written in a way where it's vague enough to where different contexts allow for certain sentencings to end up tending to need to be below the sentencing guidelines, which is why I think it was 59% of judges sentenced below the guidelines for these types of things.
Dealing with here is an issue which even this committee and members on the committee have been loath to address again.
Congress tells judges what we're supposed to do when we sentence. But as it currently stands, the way that the law is written, the way that Congress has directed the Sentencing Commission appears to be not consistent with how these crimes are committed. And therefore, there's extreme disparity, as you pointed out.
Right. So it's Congress's job, unless Congress does a bad job, because then it's my job. And the only measure of bad is what? Her own subjective personal opinions, she originally said, have nothing to do with her decision-making as a judge. And for my money, without...
No, but the argument is that these guidelines apply to a different context. They don't apply to this context. They were created... When you actually look at how they were written, how this law was written. It was not written to apply to this context. It was written to apply for like receiving photographs in the mail. So
diminishing the seriousness of the other issues, that was the most disqualifying moment of these hearings. Awfully ironic, considering that was the first exchange designed to protect her from the damage to come. But all the damage was already done by her own reasoning and that of her handlers, which makes it even worse to me, because this is what she explained with preparation and forethought. This is not something she was trapped into by a stressful moment or some surprise attack. What she said there is that the law as it's written is the most important unless and until I decide it was written poorly, in which case, as it's written is not the most important, my own personal discretion is. That is not the philosophy of a neutral arbiter, as she claimed to be. That is the philosophy of a queen who believes that she holds the ultimate right to transform the law as she wants it to be, not apply the law as it was written, even if it was.
No, she's still applying the law as written, but she's applying it in a context. But I don't know. I'm just going to keep repeating myself. I don't think these guidelines are intrinsic guidelines that the judge necessarily has to follow that's not the way they were written, and that's not the way that they should be written either, in my opinion. I think we do need to leave some judicial discretion based on the context of the crime. That's not saying that she's not applying the law. She's still applying the law. She's applying it in a context. So the sentencing needs to reflect that, I think.
Written poorly, badly, or unwisely. That's not a philosophy.
And yeah, I can react to your video after this one is done. I need to focus.
That belongs anywhere on the bench, but at least in lower courts, that thinking can be overturned. Put that thinking on the Supreme Court, though, and as we've seen with way too many landmark cases prior, it creates new law out of thin air that applies to everybody in the entire country with a lifetime appointment to do it, and no direct accountability to the people. When laws are bad or insufficient, the mechanism to fix them is exactly that. It's the people through their chosen representation, not the supposed wisdom of unelected black-robed elites. That is the principle on which this nomination ought to be opposed. But like many other political lessons these days, it looks like we're content to learn this one the hard way rather than think about it carefully ahead of time. But I guess if Jackson just proved anything, it's that thinking about things ahead of time is highly overrated. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on Gab.
Awesome. So yeah, I think I said everything that needed to be said, and if I keep going, I'm just going to repeat myself. So I will end this particular reaction and move on to Momo.